Good morning, everyone. Just waiting for a few more people to be joining today's session. Great to have you here. Welcome to today's webinar. We have about a 45-minute session today. We can run slightly over. The session is Risk to Resilience, so an opportunity to strengthen your contingent workforce strategy. I'm Anna Hopkins, Strategic Partnership and Growth Manager at CXC, and I'll be your host for this session. And I'm delighted to be joined today by two experts in workplace law and contingent workforce risk and compliance who can help answer some of your questions and bring to life some of the headaches, but also some of the opportunities we have, and to give you some practical advice on how to deal with those. So we have Nick Dougal, National Practice Lead from Moray and Agnew, and we have Chris Thule, CXC Director of Risk and Compliance. Welcome to the both of you, and thank you for agreeing to be in the hot seat today and support this session.
Thanks, Anna.
Hi, morning. So the world of contingent workforce continues to be a risk and compliance challenge, as many of you know. We hope today to give the opportunity to ask some questions of our experts, to give you some practical advice. And we also wanted to talk to you about the sometimes overlooked opportunities there are to unlock the full potential of your contingent workforce. Today's session will be interactive, so we'll be recording the webinar, so feel free to take notes, but also know that you'll have a recorded version sent around to you post the session, along with an ebook containing some of the content we cover. So do feel free to focus on the conversation, knowing that you can play that back at your convenience. And so we'll look to be done in around 45 minutes, as I mentioned. Myself and the speakers will be available for a little over, though, to run to the hour if you'd like to ask more questions. Thanks for those that completed the registration survey. That really helped us. We've made sure that we've covered the pertinent questions in the content today. And if anyone else wants to use the chat functionality, please do so throughout the session to pose a question, and I will try and manage that at the appropriate time to hand those questions to the speakers. Okay. So let's get going. So we all know that there are several areas of inherent risk in engaging contingent workers. I'm going to ask Chris to start by just honing in on some of those risks around miscategorization of workers at the entry point to an organisation and the current trends and things that we're seeing going on in order to deal with those. Over to you, Chris.
Yeah, so organisations across industries are embracing flexible talent models, and organisations that we know of in the market and those that we deal with, to respond to faster to market demands, tap into specialised skills, and optimise operating costs. The contingent workforce comprises, it's a blanket term that comprises freelancers, consultants, contractors, casuals, and what you might call non-permanent staff, and it's become essential to this agility. However, as reliance on contingent talent increases, so must the sophistication of the systems that support it. Compliance now needs to evolve in line with these shifting needs. We all know that recent changes to Australian legislation have meant that deciding whether a particular engagement should be a fixed term, a casual, an independent contractor, or that term SOW, statement of work, is difficult enough. But then new ongoing obligations under each of these categories make it increasingly difficult for businesses to manage without help. Miscategorization can lead to the most heavily penalised mistakes, including inaccurate tax calculations, superannuation allocations, long service leave provisions, and at worst, underpayment of workers that, as we know, can blow up and cause large-scale reputational damage, and we've seen that in recent years. The model you deploy will determine who is responsible for categorisation of workers, but leaving this important entrance into the organisation unmanaged is now, in my opinion, incredibly risky. Some of our clients continue to have hiring managers own the engagement of contractors, but tools and education are paramount to ensure that risk is managed appropriately. CXC has developed a number of tools that work well where talent acquisition and HR are not involved in the initial engagement and hiring managers require guidance. Of course, these are developed in conjunction with organisations and their policies, but serve as a way to promote business agility and ownership of resourcing.
Thanks, Chris.
So yeah, is there any questions?
Seeing any questions so far, Chris?
Okay, well, yeah. Sorry.
Yeah, I think it would be useful to maybe hone in on some of the specific changes in worker categorization and any trends we've seen on the back of that. Nick, are you seeing anything particular shifting with organizations' focus?
Yeah, look, and I think where we are at the moment with the management of contingent labour is that we had some very substantial legislative changes in 2023, the closing loopholes legislation. That round of legislation was quite focused on contingent workers. And it created a whole new range of additional compliance obligations for those involved in the procurement of contingent labour. There was a new definition of casual employees. There was a new or return to an old definition of independent contractors. There was the creation of a new jurisdiction of same job, same pay, which regularises the pay rates for on-hired workers. And that was also, and Chris was right to point out that one of the biggest risks associated with misclassification is the prospect of underpayment, and in particular, underpayment of a class of workers. What we've also seen recently is the criminalisation of underpayment for directors. So all of this just really raises the stakes of compliance with contingent workers. Since that legislation has taken effect, we have seen some case law. Certainly there's been activity in the same job, same pay jurisdiction, and that's leading to a lot of complexity, in particular to the mining and resources sector. Other aspects of the legislative changes, for example, the new definition of casual workers, it's taking a little bit longer to see some of the binding authorities, but it's very much continues to be an environment for those in the contingent labour sector, where they're in a sector which is very much under scrutiny. And it'll be interesting to see now, Anna, how that changes or even increases that scrutiny in light of the recent federal election, given that most of the scrutiny that we're seeing in this sector is driven by legislation rather than case law. That's just a bit of an upshot.
Yeah, and digging in a little bit further to these areas that Nick's mentioning and that I mentioned earlier, the definition of an independent contractor, as Nick said, we've gone back to the future. It's more of a grey area than it was 2-3 years ago. Now, we've kind of started to get to something that approximated certainty, and now we've gone back to what we had before. So courts are increasingly ruling in favour of employee status, leading to back pay claims and penalties. Businesses must de-risk contracts to ensure they clearly outline contractor status and avoid unintended employer obligations. It's, of course, important to meet the criteria of independent contractors as defined by the ACO and Fair Work Ombudsman, but often, even though this is set out at point of entry, the way worker is treated, if left unchecked, can evolve over time and blur lines. And that's really the crux of the devolution, if you like, of this area of law, is that we've gone back to what they call the whole of relationship test. So instead of the previous case law, which reinforced the previous definition of an employee to a view that if you had everything in order in the contract, that you would be largely protected. This new definition of employee moves us back to a world where what happens in the run of the engagement between you and the worker continues to be important and could be brought up in the courts as evidence that someone has been misclassified. Also, casual employees has been a flashpoint. Casual employees are entitled to casual loading in lieu of annual and sick leave benefits, and in most states, and especially in WA, they're eligible for long service leave as well as superannuation payments. They have the right to request permanency, look, especially with long service leave, the complexity of state-based requirements and nationally leave requirements can be complex. I challenge anyone to stay across all of the different requirements in every state. If you're a national business, it is a big challenge. We're seeing clients start to outsource areas and programs that engage casual workers, such as internships, call centres, even graduate programs in some cases, as the risks are becoming too challenging to manage. We are seeing organisations look at how many casuals they engage and start to think about the opportunities to put third parties in between the worker and themselves. This can help when permanency claims may arise. And of course, the fixed term contracts, which was in many ways a little bit of a safe harbour for organisations that in the past. They're still popular, and there's no real evidence that the number of fixed term contracts is diminishing as a result of the legislation that was passed in, I think it was late 2022. But ensuring these arrangements do not go on beyond the 2-year statutory limit is an important action that, from a compliance perspective, that organisations need to be looking at. There are exceptions, but those exceptions are yet to be tested in courts. So it's really something that you need to look at as an organisation. And of course, I mentioned earlier the great SOW, the statement of work. It's a term that can be used to catch any number of arrangements. In fact, it's become a little bit of the type of term that people use, and no one really knows exactly what they mean by statement of work. And we're seeing statement of work contractor engagements skyrocket. And they are popular, as that would indicate, but many organisations don't fully understand what they are and how to use them to maximum potential. Organisations, perhaps with the intent to comply with restrictions, we've talked about all the restrictions that are being placed and all the legislative changes around the other types of non-permanent workers, but the organisations are seeing statement of work as a way to may potentially avoid some of the challenges in these areas. And so we're seeing more organisations push arrangements into this category. But we're also seeing a lot of organisations, as a result of that, reach out to us to support the correct application of the statement of work arrangement, or to analyse a large amount of spend in this area. In some cases, we are posing the question to organisations that we deal with over whether this is the most cost-effective way to access this talent, and does it really pose less risk? And that can only be answered in your specific circumstances, of course. So that's why organisations are coming to us to understand what this increasing and growing statement of work population actually is, and what are the risks that sit within that for them.
Yeah. Are you concurring, Nick? Are you seeing that kind of shift for the statement of work, and do you see any, challenges and risks there that may exist?
Yeah. So one comment I'd make in relation to statement of works is that it's not a mode of engagement that has any legal providence. So courts don't look at an agreement labelled a statement of work and put such arrangements into a particular legal categorisation. So really they're essentially a label or a title for a form of independent contractor agreement. Now, I think, having said that, I think they are useful in that expressing an engagement as a statement of work and populating the terms of that engagement with standard of statement of work terms tends to be of assistance in classifying that arrangement as one of a genuine independent contractor. And in that respect, I just want to comment on something that Chris appropriately mentioned in relation to the classification of independent contractors somewhat going back to the future. In a way, it's quite ironic. Normally, what we see in the workplace relations space, and probably more broadly than that, is sometimes we get case law that is made in isolation that's not workable for industry on a macro scale. So legislation therefore needs to step in and simplify or codify what is legal. Here we have the opposite. Here we've had the High Court come in and simplify the test for what is an independent contractor by saying that primacy is given to what label is ascribed in the contract. But then we've had legislation step in and say, no, you don't, it's not that simple. You need to go back to the multifactorial test and look at everything in close context, which is a very impressionistic and judicially discretionary exercise. So I think industry's got every reason to be frustrated that they can't just get a binary or a straight answer on what an independent contractor is. Now, to my mind, the only real solution for industry is to engage your independent contractors via a third party. That might be the contractor's own services company, so it's still company to company, or using a genuine third party like a CXC. If you are going to engage an independent contractor as a sole trader, i.e. someone who's an individual who has an ABN, unless it is a really, really specific engagement for a limited period of time, you are running the risk that they could be found at law to be an employee. So yes, I would be recommending statement of work type models to assist with the classification, but I think, industry should be really wary of how it directly engages sole trader independent contractors going forward.
Yeah, absolutely. Thank you, Nick. We had a question come through on the registration process. Of course, another thing that has stepped in to challenge us. The ACIC's request around onboarding checks, police check, and those kind of checks that are required to onboard contingent workers, and how that relates to the Privacy Act. Nick, would you just like to cover that for us in terms of your take on that and what you think organisations can do practically to help that situation? That new request?
Yeah, sure. So some of the sort of standardized criminal check third-party services limit what the information that is supplied about someone's criminal record to who that can be disclosed to. So often, if a party, the executor of the criminal check, who might be also the party who employs or otherwise engages the individual, might be subject to restrictions in relation to who they can disclose the particulars of that criminal check to. So I think there's two ways. First of all, the party who is executing the criminal check should check carefully the terms upon which they can disclose the information coming back from that check. Now, if disclosure is restricted, then I think that the two things that they can do is procure consent from the individual as to what information from that criminal check is disclosed to third parties, which then obviates privacy issues. Or the other thing that they can do is settle with their end client in relation to how that criminal record check is utilised. For example, it might be sufficient for the engager of the individual to not disclose to the third party the specific details of that criminal check, but for them to be agreement with their client as to what kinds of criminal records would render the individual unsuitable for placement, and then leave the third party to just accept what the labour supplier says. Like, for example, we've done a record check, we're not going to be putting that candidate forward, something like that. The other thing I would say is that criminal record checks can be a source of discrimination protection, but not to the same degree as other protected attributes. For example, that they're not subject to the same protections as, say, gender or disability or family responsibilities or political opinions, things like that. So they're the things I'd probably be mindful of in that regard.
Yeah, thank you, Nick.
Yeah, and look, it's certainly that reflects the experience from a CXC perspective. Prior to even the recent uptick in this, I guess this area, because of the ACIC's restatement of what they claim to be their what was always the case. They've CXC has always recommended to clients that it's not, we're here to carry risk. That's part of our role as a third party. And while we like to understand, we work closely with our clients to understand their culture, to understand what kind of what the roles are, where the people are being placed, and how important the roles are. Clearly, a person with a fraud conviction who's going to be working in your finance department is very different to someone who's going to be driving a truck. So there's a range of conversations in our implementations that we have with our clients to understand, contractually, if you like, even though it may not be written into the contract, it's certainly in our documentation, how organisations want to move forward after checks come back with a disclosable outcome. And so we'd certainly recommend that when working with suppliers, such as CXC, that you do have those conversations ahead of time, as opposed to waiting until something happens and all of a sudden you're being told something that you can't be told, that you shouldn't be told, or you can't be told something you want to know, and there's just no system in place for those organisations to occur. And I do agree with the point that was raised in the chat, that these by Nalini, thanks for the comment. These checks are point in time. They can only tell you what is currently in place. We've had situations where people are actively involved in court matters, and because those matters haven't been decided, they're not in the they won't be in the check. So yeah, that's a slightly a new challenge that has come across over the past since late last year. Thanks, Anna.
Yeah. So just another thing to add to the list of things that we have to be across and concerned about. Okay, so we've looked a little bit around categorization, around that new clarification on some of those privacy elements. Chris, it would be good to kind of get a few of your recommendations on some of the practical steps just for organizations to ensure that generically they have across all of their kind of on-demand or contingent workforce. And we can develop some more content on these in our ebook and send around, but I'd wondered if you just go through some of your recommendations.
Yeah, we've talked about how classification is the most important thing. So, but you know, we live in the real world, all of us on this call, where companies or organisations need to bring workers on into their organisation, and sometimes quickly, and sometimes with out a lot of time because it's urgent or it's a business requirement. So while we could live in this perfect world where there's a worker classification tool and everything can be done and you've got all the time in the world, that's just not the reality. So we recommend a range of strategies because each organisation will have slightly different challenges, and we can certainly recommend the ones that kind of suit each organisation the best when we're talking with prospective clients. So first of all, regular workforce audits. So that's really the question of looking at the data that you have to ensure that contracts are in place, that tax obligations are understood, and that worker classification aligns with regulations. So that's certainly probably not that's more of the sledgehammer end of things, running a full audit, but certainly it does help. You can also use automated compliance tracking to flag inconsistencies. So there's certainly a range of software compliance tools that you may have access to or that you can get access to that could assist as well, that might reduce some of the manpower side of the audits. We recommend maintaining centralised records for contracts, taxes and benefits. It's unfortunate that a lot of organisations that we come into contact with don't have centralised records. They don't necessarily know where to find the information that really drives these important risks. They could be held by hiring managers. They could be held by hiring managers who are no longer with the business, for example. So looking at how that's centralised and how that information is organised is vital. We talk about reviewing workforce composition quarterly to ensure staffing patterns match market demand. So certainly I'm not going to sit here and pretend to understand your businesses, but sometimes what happens is organisations will bring in contingent workforces to manage peaks and troughs in demand for their services. But what sometimes happens is organisations end up with a rump of contingent workers who are actually servicing what turns out to be a permanent level of demand in the business. And so one of the big drivers of misclassification is this the type of job that you need to have people do all the time in your industry? And if that's the case, then it may be worth looking at whether or not the classification of not the individual, but the role itself that the individual is filling. And so maybe if you do have some turnover in that team, you can look at saying, well, let's look at making some people permanent as a possible solution. Or if it is a project type situation where people are, you just genuinely don't know the demand or how long things are going to be, that's fine as well. So that's really what we're getting at there with the workforce composition. And look, as talent acquisition and procurement professionals, as most of people on this call are, you really need to tailor your approach to the business that you're servicing. You know, there's absolutely no point in trying to put something in place that is not going to be adopted by the business, because you're just going to end up in a worse situation than you were before, with a lot of effort and not a lot of a dividend. So definitely would recommend tailoring your approach to the business that you work with, and getting buy-in from senior management, from senior leaders in the parts of the business that you need buy-in from, and that certainly should result in better outcomes.
Perfect. Thank you, Chris. I think one of the other things we're seeing as a trend of organisations is this notion around having those maintained centralised records with regard to things like emergency management. In the event of cyclones, floods, fires, things we have to cope with. Sometimes
we seem to have them all the time, Anna, now.
Right.
So yeah, we certainly had clients who came to us in the aftermath of natural disasters, where their concern was their inability to contact their entire workforce at any particular time. So we've certainly been able to help with that at CXC.
Yeah. Just another reason for that kind of being across who you have being really important. Okay. All right. Any questions from the audience? We're all pretty quiet today. That's fine. We did take some questions to filter through the content in the registration process, but feel free to drop those in the chat if you have them. We wanted, as well as focusing on compliance and some of, I guess, what seems as we talk to be some of the headache areas, to have a think about how we actually can leverage this important workforce. So we've spoken about the shifting employment landscape. The on-demand workforce has rapidly evolved from, I guess, a tactical fix, as we mentioned before, like, try before you buy and those kind of financial cost savings, to a strategic asset. So no longer just a way to plug resource gaps or cut costs, but more around driving innovation, flexibility, and global reach. So we do see that there's an opportunity to build a really agile, resilient workforce that can respond to business goals by bringing new skills, new thinking, and helping shift the dial on important business priorities. As a result of that, and kind of the shift in where we'd like to see that non-permanent workforce being leveraged, we're seeing models focus on and encompass contractor wellbeing as a key element. Wanted to talk a little bit about that today. So organisations seeing the opportunity to make sure they have a not only tracked and managed, but healthy and well supported key element of the workforce. And there's a few observations on that. We're seeing a trend in legislation being passed that actually incorporates contractors into some of those workforce requirements that may have historically only been relevant to perms. A recent example of that would be the recent Victorian government's decision to take the psychosocial regulations passed a couple of years back and develop a version of those that actually sees them adopt those for all their contractors as well as permanent workforce. It'll be really interesting to see if other states follow that. So if we're to see that trend continue, to consider contractors included in those emerging regulatory environments, should we be more aware of who our contractors are and be more mindful in how we engage them and look after them? And how do we do that without contravening some of those complex areas of legislation that Nick was referring to around categorisation and how we treat workers? So not an easy task. But getting ahead of psychosocial hazards seems a really good place to start. And we're seeing a lot of organisations take to that. So we all know that mental health conditions are associated with increased increased loss of productivity, the median lost time for mental health conditions being 34 working weeks per serious claim compared to about 8 for all other injuries and diseases. So a significant loss of productivity and an area that organisations are focusing on. So just another area that we are seeing those that are building contingent workforce or on-demand workforce programs are building into their thinking and to their models. So yeah, I guess the overall contractor wellbeing model is something that is bespoke to the organisation, but obviously having a consolidated view, whether it's direct to the or having a third party manage those, there's often more scope for a strong holistic program. This is just an example of some of the elements that we would implement in a wellbeing program, but just to ensure that your non-permanent workers are being considered, whether it's their emotional and physical well-being. Also looking at important areas, financial is obviously really important to those individuals, whether that's through giving them access to financial support, financial planners, whether it's around the way they're paid and giving them options to that is really important. Social interaction, and obviously where they reside is important for that. Really important for some of those remote workers and the increasing kind of gig workers that we have that can be out of the office and remote working. So yeah, just to kind of put up there, like it's very, it's one thing to ensure those compliance risks are covered, but actually this area is coming much more into that risk and compliance radar, just around ensuring that these workers are managed. I'd be interested of this group, and maybe you guys can pop in the chat, how many of you are actually focused on this or have some kind of program or use a third party to run such a program. I'd be interested to know.
Yeah, Anna, we've certainly seen a lot of challenges. Unfortunately, the risks associated with some of these areas do spill outside the employment area. So as much as we as CXC and other organisations want to protect risk associated with these areas, it is really a team effort between an organisation and a third party as to how they address these things. And certainly we have relationships where certain aspects of this are managed by us as a third party, but other aspects are monitored internally as well.
Yeah. I'm just seeing in the comments, obviously there's a bit of a mix, and we've got some organisations, yes, for direct employees, but not for labour hire consultants. And I think that would probably be safe to assume in some of the conversations I'm having around organisations, the norm. So yeah, we've got another one saying that. So I think that's probably, it is the standard, and interesting to think that Victorian government stance on ensuring those psychosocial risk management extends out to contractors, whether that is an area that organisations will start to focus in on more, an important one, I think. Nick, do you have a view?
Yeah, I've probably got two thoughts.
Yeah.
One is end users of contingent labour should be very careful about how they induct contingent labour workers. If you think about, for example, a construction site, any individual who enters that site will be inducted from a safety perspective, quite prescriptively. They'll have a structured half an hour or however long session about all of the safety considerations for that site. I would encourage users of contingent labour to induct their contingent workers who come on site in the same way in relation to psychosocial risks. And because that risk is really twofold. One, what conduct they might be subject to by the end user's direct employees, but two, also what conduct they might subject the end user's direct employees to as well. So I think, I would take psychosocial risks in the same way that you take physical risks on a work site where there's significant physical risks. That's first thing. Second thing is that one of the risks arises in terms of misclassification is where you have this kind of blended workforce, and you can't tell the difference between the direct employees and the contingent workers who might be, for example, independent contractors. That they might have the same benefits, they might have the same uniform and name tag, they might have an email sign-off. Now, all of those things can be factors in relation to how they're classified. So to have someone like a CXC that has its own kind of benefits and other arrangements uniquely to contingent workers can be helpful in that respect.
Yeah, absolutely. And I see in the chat, wouldn't that become more of an employee relationship? Are the risks around providing those same benefits as employees? And I guess the yes is the answer, I guess, to that. And so, that said, fair to say that I guess the holistic well-being of anyone that is working for you would deem to be important, and you see governments weighing in on that and setting those standards. So interesting topic. Yes, it's easier for a third party to have those, and I guess maybe for organisations, it's around getting a hold of your entire the workforce and understanding who owns the well-being support and who owns those psychosocial risks, which are different but related but different.
And I would absolutely concur with that. It's not necessarily, the first job is to know who's who in the zoo, so to speak, to know who's as Nick said, the difference between I've come across situations where we've had clients actually lodge workers' comp claims for our workers before they realise they weren't their workers. And then it has to be backed out. And so that lack of visibility can be a huge issue. Risk, look, my job title is Director of Risk Compliance. I understand risk, and Julie makes a good point, but you also need to understand what risks, you don't want to go so far to protect yourself from a risk in one direction and find yourself finding risks on the other side. So if you do so much to, separate yourself from a person who's working in your environment, in order to manage employment risk, you are possibly subjecting yourself to risks in other areas, such as with, for example, bullying claims can be made in the Fair Work jurisdiction against clients, third parties who are not part of the employment relationship. So it's just an example of a situation where don't be too focused on one risk. Unfortunately, we've got a range of them, and certainly I agree. Using we at CXC we deal with contingent workers. That's all we do, and so that certainly has a benefit to organisations we work with. So I'd certainly encourage organisations out there to know what they've got, and then design a strategy that suits what they've got, not just some generic kind of idea of what might be good and what might not be good. Back to you, Anna.
Yeah, absolutely. Just a couple more comments in the chat. It comes down to cost too, and what organisations have budget for, how that's treated in the P&L. which absolutely makes sense. And we are seeing probably, again, just trends in organisations not pushing that, but requesting third parties to supply that as part of the negotiated fees. Anything else in here? Anyone got any further questions? We are around for a little longer if there's anything specific that you'd like us to cover off. We're nearing the end of our content as planned. Just to comment, a lot of these contingent labour providers have their own programs to retain and attract employees. Yeah, absolutely. And I think one of our new, some of our newer services are around providing those programs to contractors, including the reutilisation of contracts, so platforms where they can find new roles, as well as providing some of these wellbeing supports.
I would agree. I would agree with that, Anna. The only caveat I would say to Christelle's message is know what your providers are doing and what you're doing. You don't want something to fall between the gaps between your providers and what you're doing. And you don't want to also double up, I guess, is the other risk that could go in the other direction. So that's absolutely true, but it's important that you understand that.
Yeah. So the message is, key messages is probably around getting that visibility, being thoughtful on these areas, having a strategy, whether it's your own strategy, whether it's managed by a third party, audit records regularly. Anything else, Nick and Chris, that I missed as a quick summary? Yeah, ask the experts. Perfect. All right. Thank you so much for everybody. Thanks for showing an interest in the areas that we're passionate about and the areas of our expertise. As I mentioned, we'll issue you an ebook and a recording of the session, and we'd love the opportunity to continue the dialogue. So if you need to, please feel free to reach out to any one of us. Have a wonderful rest of your week, everyone. Thanks for dialing in and participating in today's webinar, and thanks so much, Nick and Chris, for helping facilitate the questions in that session. Thanks, guys.
Thank you very much.
Thanks, everyone.
Take care, guys. See ya. Bye.